Please be seated. This morning, the Chamber will have the trial management meeting for case 002/01. As the President on behalf of all the judges of the trial chamber, I would like to welcome the co-prosecutors, the defense teams, and the lead co-lawyers for civil parties who are present here this morning. The purpose of this final trial management meeting in case 002/01 is to permit the parties a last opportunity to raise any issue whose resolution is still outstanding at trial. And after the TMM, the Chamber intends to schedule the last remaining hearings at trial, and once they conclude, to announce the close of evidentiary proceedings in case 002/01. To facilitate this trial management meeting, the Chamber issued in advance of it 4 annexes to the parties. The first 3 of these annexes provided the parties with the Chamber's tentative disposition of all requests to hear oral testimony at trial. The parties, over the course of case 002/01, have requested to hear a combined total of 1,054 witnesses, experts, and civil parties. The first of these annexes indicated those individuals relevant to case 002/01 whom the Chamber intends to hear at trial. The second annex lists those individuals sought by the parties in case 002/01 whom the Chamber has decided not to hear at trial. The third annex lists all individuals contained by the parties on their original Rule 80 list for the entirety of case 002, but who were not considered by any party to be relevant to case 002/01. All decisions in relation to this latter annex have been deferred to future trials. The parties over the course of the trial have been provided with multiple opportunities to identify relevant individuals to be called, and the purpose of this trial management meeting is not to repeat these earlier requests. It is instead to grant the parties a last opportunity to raise any genuinely novel issue regarding these annexes and the individuals they identify. The parties have, in advance of the TMM, identified a number of additional witnesses they seek to hear at trial, and opportunity will be provided today to discuss these requests. The Chamber will decide on these requests shortly after the 3mm. In advance of the TMM, the trial chamber also issued a fourth annex outlining all 285 motions filed by the parties over the course of the trial in case 002/01. In order to assist the parties in identifying any last remaining issues, the Chamber has linked all motions and requests with their corresponding decisions rendered at trial. A small number of motions remain pending before the Chamber, and in order to aid discussion at the TMM, the Chamber has provided the parties with advance notice of their likely disposition. The parties were requested to provide the Chamber advance notice of the issues they wished to discuss at the TMM. All parties have complied with this request, and this has greatly assisted the Chamber in planning. Before proceeding to discuss the 17 additional witnesses sought by the parties to be heard before the conclusion of the trial in case 002/01, the Chamber will first dispose of all other issues raised by the parties in advance of the TMM. Now on the final document hearing. At the conclusion of the testimony of witness TCW 801, the Chamber will hold a final hearing to permit the parties to present key documents in relation to joint criminal enterprise and the role of the accused. It is likely to occur during the week commencing 24th June 2013. The co-prosecutors have requested that they be allocated 3 days in order to present key documents at this hearing. The lead co-lawyers have requested the same amount of time. The Chamber would like to inquire as to whether, in seeking these time allocations, the lead co-lawyers and the co-prosecutors have collaborated to ensure that they will not present the same documents at this hearing, or might otherwise give presentations that are duplicative. And for that reason, I would like to give the floor to the prosecution and the lead co-lawyer to clarify this matter. The prosecution, you may proceed.
Good morning, Mr. President. Good morning, Your Honours. Good morning, Council. Your Honours, in relation to the document hearings, as Your Honours have stated, we have asked for 3 days. And the 3 days is in relation to the policy of forced transfer, work sites and cooperatives, forced marriage, enemy policy and targeting groups. We haven't spoken yet with the civil parties, but we will endeavour to do so to try and ensure that the documents that are presented are not duplicative. So we'll do that in the next day.
Thank you for your information. The lead co-lawyer for civil parties, you may proceed.
Good morning, Mr. President. Good morning to everybody here. Very briefly, we are, of course, going to discuss these documents. I would like to tell the court at this juncture that we have decreased the time that we are going to be needing, and that we'd like to say now that 1.5 days will be quite enough for us. And of course, we will liaise to make absolutely sure that there is no duplication. Thank you.
President, thank you for the information. Judge Lavange, please proceed.
Would it be possible for the lead co-lawyers for the civil parties and for the prosecution to tell us if they have already prepared their lists of documents that they are planning to table at the presentation, and if they have exchanged the lists with each other? So I'm really asking you what stage of preparation has been reached. Thank you.
Thank you, Judge Laverne. Just to even be slightly more accurate, the estimation of the document hearings from the prosecution's perspective was 3 days, but that was including the role of Nguyen Chia in Democratic Kampuchea. So the document hearings purely on the JCE policies, that is, would be, we estimate, 2 days, just under 2 days. As far as the state of preparation of these hearings, most of them are in a reasonably advanced state. But as far as an accurate list of documents, I would say that would be, they would be available more towards Monday than this afternoon. But they are in an advanced state of preparation, Your Honours, and so we could provide those lists to the civil parties, I would say, by Monday afternoon to assist them.
Thank you. The lead co-lawyer, you may proceed.
Just to be specific, we have reserved our rights to submit documents on the two accused. So 1.5 days for us concerns the two accused and JCE. We are reasonably well advanced, but we are far from the end. To be perfectly honest, I'm not sure we will have finished by Monday, but we will certainly try to finish in the course of next week.
Ces informations.
Judge Laverne, thank you for that information.
President, thank you, and thank you, Judge Laverne. The Nguyen Chia defense have indicated that they do not, as such, wish to present key documents at this hearing, but have requested a maximum of 1 day in order to respond to the document presentations of the other parties. In its motion E263, the Khieu Samphan defense submits that the key document hearings violate the accused's right to a fair and adversarial trial, insofar as they are not intended to allow adversarial argument in relation to the documents presented, and due to alleged inconsistencies regarding the conduct of these hearings before the trial chamber. They submit that the Khieu Samphan defense must be accorded a real opportunity to discuss all accusations against the accused, and that further hearings on the admissibility of documents ought to be scheduled. The Khieu Samphan defense also submit that key documents presented so far should further be examined for probative value so as to permit full adversarial debate, and that opportunity be provided at the end of proceedings for a thorough assessment of the entire body of evidence against the accused. The Chamber has previously explained that the key document hearings, which were held at the conclusion of each trial segment, are required because there is no need within the ECCC legal framework for documents to be tendered only through relevant witnesses or experts. These hearings were designed to permit the parties to indicate, for the benefit of the Chamber, those documents alleged by them to be of particular relevance to each trial segment. The Chamber has previously emphasized that the purpose of these hearings is to ensure that both inculpatory and exculpatory evidence is appropriately highlighted before the Chamber. These hearings serve also to permit a greater measure of public accessibility to the documentary aspects of the trial in view of the vast size of the case 002 case file and the unlikelihood that the general public would otherwise be aware of the contents of these key documents. As separate hearings were held specifically to enable challenges to the admissibility of all documents tendered at trial, arguments as to admissibility were not permitted during the key document hearings. However, the accused or their lawyers were never prevented from discussing the relevance or probative value of the key documents presented during them. In the light of the Kills and Pons defense's allegation that they lacked adequate opportunity for adversarial argument in relation to these documents, the trial chamber invited the Kills and Pons defense to indicate at this TMM how much time they now require for this purpose and to specify the documents to which they wish to further object or comment. Could the Kills and Pons defense now provide these indications? You may proceed, counsel.
Thank you, Mr. President. Good morning, everybody. The position of Kills and Pons defense team remains unchanged. As we see it, these key document hearings are not at all connected with a judicial trial. And in a sense, we are locking the stable door after the horse has bolted, because here the system seems to be to examine a certain number of elements and testimonies during a public trial, after which, as happens in international trials, an opportunity is given to all of the parties to exchange memoranda and submissions, and in which they examine the documents that have been filed during the trial, and finally they have an opportunity to respond to each other in writing, or if not possible, then in court. The basic, normal, shall we say, process for a trial is that. Now, these instances where we discuss key documents have varied somewhat in the way they have been organized. At the beginning, the Chamber said that the purpose was only to present documents for public benefit and for the benefit of the media, and we protested against that and said that we were not journalists, nor were we media people, Obviously, the public has to know what we are talking about, but our mission is judicial, in essence. And when you look at the way in which things are being conducted today, our position is to take note of the fact that under the pretext of the fact that we have these document hearings, we end up in a situation at the end of the trial where we are going to be granted for our final submissions 100 pages roughly in a trial which lasted several years, including almost 2 years of hearings with 70 witnesses coming before the chamber and several thousands of documents up for discussion, and we have to put down on paper our final conclusions in 100 pages. Well, accept my apologies, Mr. President, but this is extremely restrictive. Gradually, we are coming to understand that we will have certain time limits for the final statements. And basing ourselves on a memo, I believe, Memo 282, Mr. President, saying that our final arguments should be a summary of our 100-page document. Consequently, our position remains unchanged. These hearings that were initially announced as being essentially for educational purposes, you might say, have become a kind of cover for the chamber to slice away at the defence's possibilities leading to a defense of Mr. Kyusampan of 100 pages and a few hours of final pleading. We believe that this is a very serious violation of a right to a fair and adversarial trial, and we don't think that this is acceptable. For that reason, we therefore refuse to participate in these hearings, which, for us, Mr. President, seem to be something of a trap. That's our position. We would like, once the trial is over, for us to look back and think that the trial was properly organized and that we had full time to submit all of the evidence and all of the documents that we wish to present, and to have all of the time to answer our opponents. No, that's all. We're not challenging the severance order or anything like that. All we're asking for is a normal, fair trial. And for us, there is a direct connection in this debate to the uncertainty that still weighs over the nature of the evidence. We have submitted several requests concerning the E3 codes because the awarding of codes to written documents that have been put to the hearings initially struck me as heavy in significance, and it seems to have changed over time. I'm not going to repeat what we have put into our memoranda, but
the President, what you have just raised will be discussed at a later stage, particularly concerning the time for preparation of your closing statement and closing brief. Just now, the Chamber accorded you the opportunity to address the chamber as to how much time your defense team need for this purpose, and identify the documents that you intend to object or to comment on. This is the issue at stake that the chamber grants you the opportunity to say about it. But your argument just now will be dealt with at a later stage during this trial management meeting. Otherwise, you will repeat the issue again, or we may not be able to achieve the objectives set for this trial management meeting. You should respond to the question at issue that the chamber would like the defense team to express your opinion in relation to the time allocation. Thank you.
What I have said is related to that issue, Mr. President. It is very difficult to separate the issues. All the issues are interrelated. We cannot isolate one issue from the other as if they were not part of a whole. It's like an engine. If you remove the carburetor, the engine will not function.
Yet you have not responded to what you have requested. Of course, we have two separate issues, and we would like to deal with your first request first. We would like to hear your intention of your application, because I treat it as a different issue.
As far as we are concerned, we would like to challenge all the evidence that has been adduced in this case at the time of closing arguments, Mr. President.
I hand over to Judge Zhao McLovin. She may proceed.
Yes. Thank you, Mr. President. You are right in saying that we should not mix up the issues, which are essentially of a different nature. Some criticisms were leveled regarding the presentation of key documents by parties during this trial. And Kyo Sampan's defense team challenged the manner in which we proceeded, saying that they did not have an opportunity for adversarial debate on the documents presented. The question we are putting to counsel for Kyo Sampan today is, what are the documents that you are challenging? And can you tell us how much time you need to challenge the documents so presented? We are not asking you to say whether you are reserving all this for the final or closing arguments, knowing that you will have a limited number of pages for each of the parties, and there will also be a limited time for closing arguments. Today we are putting this question clearly to you. Can you tell us where you stand? It is not very complicated. Do you have key documents that you would like to present yourself?
Je maintiens ma position.
I stand by my position. I am sorry to retreat from the objective assigned to us by the Chamber. We consider with a holistic view that these documents, which initially were meant only for the public, for educational purposes, are now being converted into a hearing on the merits. It is not normal. We consider that when the time comes for us to respond to all the arguments and all the evidence and all the positions of the parties, that will be the time for closing briefs and closing arguments. As far as we are concerned, these hearings are out of place. Insofar as the Chamber wants to limit the time we will be allowed and the pages, I think Kyo Sampan's team will have the possibility to discuss all the documents presented. That possibility, that opportunity is given to you today. It is not up to you to set the rules. We are giving you an opportunity to discuss all the documents that have been presented. Should we take note that you do not wish to avail yourself of this opportunity?
Je crois que le dialogue
I think there has been a break in dialogue. Insofar as we do not have the same vision of things, Your Honor, I have a holistic view of the situation, and you persist in telling me that this audience, this hearing on key documents is a highlight of the proceedings, and that is not my view of the situation. As we approach the close of these proceedings, we find that there have already been 3 hearings on key documents, and during those hearings there were no adversarial discussions and dialogue, and the parties could not react to the presentations. And now you want us to behave as if we did not face the problems we faced in the past, and you wish that we should react now. I think the only logical approach is to wait for the time for closing arguments and closing briefs. Judge Labeng, just one reaction. You are not the only defense team. There are other teams. You attended the hearing during which documents were presented, and you observed that other teams presented documents and challenged certain documents. I will quite simply read what the presiding judge said in 2012 at the hearing of the 19th of October regarding a hearing on key documents, and I quote, and it is the President speaking: "We cannot assess the weight and the probative value of the documents. The parties are not supposed to assess the probative value of evidentiary materials because we are not yet at the end of the trial. The parties should limit themselves to speaking about the specific relevance of documents because the assessment will be done only at the end of the trial." There we are. Initially, the hearings on key documents had been announced as hearings that focus on educational purposes, and I recall that at the first hearing on key documents, lawyers were not allowed to speak, and only the accused was supposed to speak with regard to the documents. Mr. Nguyen Chia, who wanted to stay in his cell, was forced to come up to the courtroom, and he was told that he had the capacity to react on documents and not his counsel. I just want to remind the chamber of the normal course of a judicial process. Perhaps for you, you think that is the case, but for the defense, I do not claim to represent all the defense teams.
The President. Counsel Kope, you may proceed.
Thank you, Mr. President. Good morning. I must admit that we are also, to a certain extent, confused about the extent of these key document hearings. If you would be able to clarify on this, are we supposed to challenge the key documents solely on the admissibility of those documents, or also on the probative value of those documents, rather the evidentiary value of those specific documents? If the first is the case, we don't have any problem. We understand the concept of key documents being presented, that is helpful for everybody, for the parties, for the chamber, for the public. But if we are now, I don't know if that is the case, but if we are now asked to also comment on the probative value of the key documents, then of course we have a completely different situation. I think that is maybe the cause of the confusion or the cause of the controversy right now. So maybe if you will be once more able to provide absolute clarity on the status of us challenging the key documents from the prosecution and the civil parties.
The President. I hand over to Judge Civil Cartwright to clarify on issues raised by the two defense teams on the last issue. Judge, you may proceed.
The term key documents is and has always been used by the trial chamber as referring to those documents which each party considers to be critical to its case. So for the prosecution, in order to assist it in discharging its burden, and for the defence, obviously, in the defence of their clients. Therefore, an opportunity has been given for each party to present those documents that they think are vital to their case as they perceive it to be. An opportunity is also given to other parties to comment on those documents, and they may comment in any way they wish except on the issue of admissibility, which has already been determined. Therefore, it is entirely within the discretion of each party to comment, for example, on the probative value of those documents, or to refer to other documents that might put the reliability of those documents in question. Throughout the hearing, throughout this trial, whenever documents have been referred to, the parties have always had the opportunity to comment on those documents. So the only matter that is not to be discussed during key document hearings is the issue of their admissibility. Now, I hope that is sufficiently clear now for the parties, and perhaps On behalf of the President, I can ask again, is Kyo Sampan wishing to present any key documents, or does he simply wish the opportunity to comment on key documents presented by other parties?
La position.
The position of Mr. Kyo Sampan's defense team is that, in light of what you have just stated, Your Honor, his position is contrary to what has been said in the past regarding the key documents, and we filed a motion E263.
Oui, je vais vous répondre.
Would you please answer the question if you wish to do so?
Nous refusons. Nous refusons de participer à.
We will not take part in hearings that violate our fundamental rights.
The President. The co-prosecutor have expressed a wish to be able to respond to Kyo Sampan motion E263. The Chamber will now permit them a brief opportunity to do so orally.
Thank you, Mr. President. I think Judge Laverne and Judge Cartwright has made a number of the points that the prosecution would like to make in relation to that motion E263. In response to my learned friend this morning stating that somehow or another the document hearings have violated the fundamental rights of the accused. As Your Honours are aware, in Article 35 new of the statute, that's where the rights of the accused are in relation to fair trial. And perhaps the one that's most particular that counsel may have been referring to was to examine evidence against them and obtain the presentation and examination of evidence on their behalf under the same conditions as evidence against them. Your Honours, in this case, just a bit of a global response. The court has heard evidence from witnesses, and the defence have been given the right to cross-examine. The court has also admitted documents, and the court has, to my mind, had document hearings at great length on the admissibility of documents, as Judge Cartwright has said, which was quite distinct from the key document hearings. And in those document hearings on the admissibility of documents, all parties were able to put forward documents to the court they wanted admitted. And all parties, including Kyo Sampan, were able to respond to the admissibility of those documents, which was done at length by all parties. And that relates to every document that's been put before this chamber. So when Kyo Sampan's counsel states that our fair trial rights have been violated because they haven't had an opportunity to challenge the documents, they've had significant opportunities in those admissibility hearings to challenge them in relation to admissibility and, as Your Honours have remembered, also in relation to probative value at that point in time, particularly if the counsel thought that those documents passed the admissibility test. So that's a complete. The defence counsel for Kyo Sampan have completely got it wrong that they haven't had an opportunity to challenge the documents. In relation to the key document hearings, which Judge Cartwright has just put forward, the purpose of those hearings was different. Those hearings dealt with the exact same documents that were dealt with on the admissibility hearings. But there were two aspects to those documentary hearings, or the key document hearings, as Judge Cartwright has stated. One was to make sure that the trial is transparent, which is also a fundamental right of the accused, so that the public would get to hear what evidence is being considered by Your Honours. How that is a violation of an accused right, it's very difficult to understand, because if the hearing was done in private and that evidence wasn't known to the public, the Khieu Sampan defence would be complaining this wasn't a public trial. And that was the purpose, one aspect of those document hearings. The other aspect of the document hearings, as Your Honours have stated, was for the parties to highlight to the Chamber key documents that they would like Your Honours to take into account. Every party, including Khieu Sampan, was given an opportunity, the same as the prosecution, the same as the civil parties, and Nuon Chea and Yang Sari, to present those documents that they wanted to highlight. It was a right that they had, but if they chose not to exercise that right, that's a question for them. But they can't say it's a violation of their fundamental rights. At those document hearings, particularly in the earlier ones, of the three that have been had, Your Honours have stated that the accused could comment on those documents. Initially, there was a little bit of uncertainty whether or not the accused the counsel could comment at that stage on the probative value at those initial document hearings. But contrary to what my learned friend Mr Verkin has said, that at all of the document hearings there's been no opportunity for the defence to comment on the probative value. If we look at paragraph 11 of E263, they state, during the third hearing on the 22nd of January 2013, the parties were given an opportunity for rebuttal or to comment on documents presented by other parties. And then they quote Your Honour Judge Cartwright, stating that the parties could comment on the probative value at these hearings, but not on admissibility. And that's quite obvious, of course, because we've had those admissibility hearings well in advance of the key document hearings. So that was a mistake, of course, by Mr Verkin. Your Honours, and I think the other issue which is important is perhaps the approach of the Khieu Sampan defence. As Your Honours can see from their motions on this particular issue from E263, they're quick to complain about problems in procedure and how the procedure is not correct. Yet at the same time, when on 3 occasions, Your Honour Judge Non, Judge Laverne and Judge Cartwright this morning have offered them directly an opportunity to perhaps put forward their submissions on the probative value of some of these documents that perhaps at the earlier document hearings, we can look at document hearing 1 and 2, that only the accused had a chance to respond. Certainly not the third document hearing, as they note in their motion. And on 3 occasions, the Defence Counsel have decided not to take up that opportunity. Again, that is a question for them. Your Honours, we would submit, bearing in mind Khieu Sampan defence do not want to take Your Honours' invitation to respond as to how many hours perhaps they may like to talk about the probative value of some documents raised in document hearing 1 and 2, not 3, because they were given that opportunity, then their right has been fulfilled. They've been given that opportunity and they've chosen not to take it. If they choose to take it, I would submit that at the document hearings on the 24th onwards, that if they choose to take it, that they be given, say, 2 hours to respond to those particular documents they have concerns about the probative value from hearings 1 and 2, bearing in mind they've had that opportunity with the admissibility hearings. Your Honours, we wanted to respond to some other matters in E263. Shall we address those matters now? And that's in relation to the questioning of... Perhaps, Your Honours, if I can have some, perhaps before I go ahead, if I can have some clarification. Does Your Honour just want our response in relation to E263, or does Your Honour want our further response in relation to the issues raised by the Q Sampan team in their latest filing to the court in relation to the questioning of the accused, the length of pre-trial briefs? We can discuss those matters now, or perhaps we'll leave it on this particular issue. It's up to you, Your Honour.
The President. Well, you should comment on only motion in document E263, and as for other matters, you will be accorded the opportunity to do so in due course. Thank you.
Thank you, Your Honour. So if we look at the motion E263, the relief that the Q Sampan team sought was first to not proceed with key document hearings. We would submit that undermines the accused's right to have a fair and public trial. If the information in those documents is not made accessible to the public, then it reduces the ability for this trial to be public. And it reduces the ability for the Q Sampan team, as well as the defence and the prosecution, to bring documents to your attention. And then I would also, in relation to their next ground, asking for Q Sampan at the end of the trial to comment on all the key documents presented, should he wish to do so. We would object to that. In relation to document hearings 1 and 2, if they require a couple of hours for that, we would ask that that be done next week in the document hearings. And certainly in relation to document 3, they've had that document hearing 3, they've had the opportunity, but they've refused that opportunity today, so perhaps it's a moot point. The third relief they've asked for is that the trial chamber would not limit the parties' closing briefs to 100 pages. Perhaps I won't respond to that now, because that relates to another issue that Your Honour would like to attend to. And the fourth ground of relief is by guaranteeing to allocate the parties the time they require to present their closing arguments. And that relates to another issue which I think is on the agenda, perhaps if I reserve our submissions until that point. Thank you, Your Honour.
President, thank you. Having received the request of all parties for time allocations for the final document hearing, the Chamber will provide more detailed indications regarding the schedule of this hearing very shortly after the TMM. In addition, the co-prosecutors have requested an update regarding the issuance of E3 numbers at trial and the likely timing of the Chamber's decision on admissibility of written statements. The latter will be issued as soon as possible and is expected within the next 2 to 3 weeks. And in any case, prior to the conclusion of trial proceedings in case 002/01. All statements admitted will then in due course receive E3 numbers. The Chamber estimates that approximately 1,500 written statements will shortly receive E3 classifications once this decision and its annexes are finalized over the coming weeks. To date, approximately 4,000 documents have been admitted at trial and have received an E3 number. These constitute the vast majority of the documents sought to be admitted by the parties at trial. The remainder, approximately 800 documents, will very shortly be afforded an E3 classification once the Chamber renders its final decision on admissibility of documents tendered at trial in case 002/01. The issue of this decision is also imminent. Now, on the questioning of the accused. Following indications that the accused intend to answer questions before the Chamber, the co-prosecutors have requested that the trial chamber allocate them 6 full days for the questioning of each accused. The Chamber notes that it is currently unclear for how long the accused will be able or willing to respond to questions from the Chamber and the parties. The Chamber will therefore not indicate time limits for this questioning, which shall be permitted to continue for as long as the accused remain willing to respond to questions, and insofar as the questioning by the parties remains relevant and pertinent to the facts at issue in case 002/01, and parties will be informed as soon as possible of the dates when the questioning of the accused will take place. This will depend, amongst other things, on the availability of the remaining witnesses, if any. The case upon defense requests advance notice of all documents to be utilized during the questioning of the accused. The Chamber agrees with this suggestion and requests all parties to provide timely notice to the other parties and Chamber of documents they may confront the accused with at this hearing. The Chamber shall also advise the parties of documents they seek to utilize for this purpose. Regarding closing briefs and closing statements, many parties have made renewed requests for the extension of the deadline for the filing of closing briefs. The co-prosecutors have requested reconsideration of the Chamber's determination in the E288 to maintain this deadline at 1 month from the conclusion of the evidentiary proceedings. The case upon defense now requests approximately 3 months for the filing of their closing briefs. Although this issue has already been extensively litigated, the Chamber will nonetheless grant the co-prosecutor's request for an extension of time to 6 weeks from the close of evidentiary proceedings for the filing of closing briefs. It cannot, however, entertain further extensions of time. Nor can the Chamber accommodate the Kirstenpon's defense request to file final briefs of 300 pages in length. As the Chamber indicated only last week in its decision E288, the previous page limits indicated for closing briefs are maintained. The Chamber wishes to note that it considers that all parts of the Cambodian Penal Code have now entered force, and while the parties have already filed briefs on the applicable law, they may still address this issue in their closing briefs, should they wish to do so. The co-prosecutors have, in advance of the TMM, requested clarification regarding the format of closing statements. The nature of this request is unclear. The Chamber has previously indicated that oral closing statements will be scheduled approximately 30 days after the date on which closing briefs are submitted. Now, can the prosecutors indicate what remains to be clarified?
Thank you, Your Honours. Certainly, those indications assist us and the parties greatly. Perhaps if I deal with just a couple of slightly outstanding issues and then ask for a couple of clarifications, if I can. Your Honour, in relation to the ruling that the prosecutors or civil parties provide a list of documents in advance of the accused questioning, I assume that would be one list, and from your ruling, the request by Q Sampan that the prosecutors provide topics, I assume has not been granted. Certainly under Rule 90 of the internal rules, there's no requirement that a list of topics be given to witnesses, well, certainly the accused, nor indeed witnesses that are being cross-examined by opposing parties. And we would submit that if that is Your Honour's ruling, we certainly agree with that, as it's important that the accused and all parties are able to present evidence in the same manner as required by Article 35 new, to examine evidence against them and obtain the presentation and examination of evidence on their behalf under the same conditions as evidence against them. So certainly the provision of topics to Q Sampan would be an unfair advantage to the other parties who it has not been required of the defence or other parties to provide topics to the witnesses in advance of their cross-examination. As far as the topics are concerned, the prosecution certainly informs the Chamber the topics that would be discussed with Mr Q Sampan and, of course, Mr Nuanchia are the topics that are identified particularly in this case. The topics that have been articulated and the paragraph numbers that relate to the closing order of this severed trial. All of those topics will be discussed with the accused. So to that extent, we have provided notice of those topics. In relation to the format of the closing statements, what the co-prosecution were referring to was how the time would be divided up. For example, Your Honours, in your memo of the 31st of May 2013, in relation to this trial management meeting, you've allocated 3 days to the prosecution, 1 day to civil parties, 2 days to the Nuanchia defence, and Q Sampan 2 days. It appears normal practice, and it certainly was in the Deutsch case, and as well as case file 1, as well as in other courts, other international courts, that the parties make their statement, the accused, all parties make their statements, and then the prosecution reply and civil parties reply to the accused statements, and then lastly the accused get the final rebuttal. So our question is, are those days that Your Honour's provided, do they include replies and rebuttals? And what would be helpful for all the parties, I believe, is how Your Honour's proposed to divide that time up between the initial statements and the rebuttals and replies. And some guidance on that would be helpful in terms of how parties plan their oral statements. Just as I said, Your Honours have very much cleared up a number of matters for us. Just in relation to the length of the closing brief, we understand Your Honour's rulings that the page limits will remain the same. What the difficulty that perhaps I understand Khieu Samphan's defence team is having, and I think it may well be, it's certainly a difficulty that the prosecution are having, is to somehow direct Your Honours to the documents which support particular allegations that each of the parties claim to have been proven or not, or disproven. So, for example, with 200 pages from the prosecution side, much of the referencing to the evidence needs to be, it could be done within those 200 pages, or alternatively, it could be provided as endnotes to the 200 pages in the same way that the indictment is structured, where the text is there, and then at the end, rather than footnotes, there are endnotes. Now, the idea is not to try and surreptitiously extend the lengths of the briefs, but what it does do, it allows all of the parties to indicate the references comprehensively to the claims we are making in our briefs. So, for example, Your Honours have said there's 4,000 documents currently admitted at trial. There's 800 that will be given an E3 number soon, and potentially another 1,050 from the written statements that will be given E3 numbers. So, in essence, the parties are dealing with 6,000 pieces of relevant evidence. And what the prosecution certainly doesn't want to do, and Khieu Samphan, and I'm not going to speak for them, but it's clear from their pleadings, they don't want the situation where we can't reference any of those or a significant number of those pieces of evidence because there's just not enough room in the brief. What we have discovered in the prosecution, that often half the page is footnoting to the allegation, and the other half is the statements that we would like to make. And because there are so many pieces of evidence, up to 6,000, we're simply not going to be able to refer to relevant pieces of evidence if we can't have the referencing as an endnote. And I think that would cure, in large part, the complaint of Khieu Samphan, and certainly we would support it, that the parties therefore have a good opportunity to present their case by indicating to Your Honours the particular pieces of evidence they rely on. The defence need a full opportunity to do that, and the prosecution also, and civil parties, particularly the prosecution as well, we have an obligation to prove the case beyond reasonable doubt. And it's important that we point, Your Honours, to every piece of evidence we think supports those allegations. So the suggestion or the request is, Your Honours, rather than, we're not asking you, now that you've made your further ruling, to vacate that ruling, but just allow the parties to reference their written or their closing briefs in the exact same manner that the investigative judges have done in their indictment. We think that the benefit to Your Honours will be far greater than the extra time in translation, bearing in mind the absolute importance of this process. The other alternative is, but I think this is a better alternative, the other alternative would be, as is the practice at the other international courts, when annexes are attached to the brief, which is a normal practice, that those references be placed in an annex. But we think it would be better if they are direct footnotes or direct endnotes to the text. So Your Honours would still receive the page lengths that you've asked for in terms of the argument, but in effect it allows the evidence that the parties wish to rely on not get lost in this process. As we all understand, millions and millions of dollars have been spent on this incredibly important process. And all we're asking, and to that extent supporting Q Sampan, is that the page limits stay the same, but the referencing be done in that manner that every party has the best opportunity to put their case forward. And if I'm just double-checking now, Your Honours, in terms of the accused testifying 1 or 2 weeks after the remainder of the evidence, we would submit that that's the Q Sampan request. We would submit that that would not be appropriate. He's had 5.5 years to prepare for his testimony, and he's been sitting through this case for the last 1.5 years. And with all of the breaks that have been had, largely due to, of course, the illness of Yang Sari and Nguyen Chia, he has had more than enough time to prepare himself for this testimony, listening to it day by day. He's in good health. He's relatively younger than Nguyen Chia. Nguyen Chia wasn't given that opportunity, and we think that there is no reason that he should have 1 or 2 weeks break. He's had 5.5 years to prepare. I think, Your Honours, they are the only matters. If I can just have one comment. The ruling of Your Honours that the E3 numbers would be issued and the admissibility of written statements would be issued as soon as possible. That is, we will certainly welcome that, just for the very reason, because as time goes on, parties obviously have to prepare their closing briefs, and knowing what's in and what's out in terms of admissibility makes a significant difference in what can be referenced in the text. I understand it's a big job. However, we do appreciate Your Honours saying that would be done as soon as possible. I have nothing further to raise, Your Honours.
President, thank you, Prosecutor. The lead co-lawyer for civil parties, you may proceed.
To briefly comment on certain points, Mr. President, with respect to the questioning of the accused, we have asked for 3 days. We can reasonably reduce that to 2 days with respect to the civil party lawyers. That's my first point. Second, as regards warning the accused in advance of the questions we're going to be asked. We are not opposed to giving the principal themes in advance, but we do wish to retain the right to be able to ask additional questions in terms of the responses by the accused. That seems to us to be an elementary right for the civil parties. As regards the number of pages, we will abide by the Chamber's decision. We have no particular comment other than the fact that we agree with the prosecutors, and I believe with the Kyosampon defense as well, in that the endnote should not be counted in the number of pages of the actual closing brief. So we do support that request. Finally, as requests, the time requested by Kyosampon for preparation, we will abide by the decision of the Chamber, but we would tend to go along with what the prosecutors have said. It seems that Kyosampon has had considerable time to prepare himself already, and the final appreciation on the situation, of course, falls to the Chamber. Thank you.
President, thank you. National Council for Kyosampon, you may proceed. Thank you, Mr. President. Good morning, Your Honours, and good morning, everyone. I'd like to make a brief response. That Kyosampon and Kyosampon's defense had sufficient time for the preparation of documents, and that we do not need additional document, rather additional time to prepare those documents. Council, I think there is some misinterpretation in the Khmer channel, in the French channel rather. I just quoted the statement made by the prosecutor and the lead co-lawyer that we do not need additional time. That is the 1 week additional time in order to prepare the documents. It is our position that we made such a request is firstly, our defense team involved in the procedural last, and the previous counsel for Kyosampon left, and then we came to replace them. And as for Kyosampon, our client himself, that had plenty of time during the past 5 years to prepare the documents, that is incorrect. Kyosampon has been in the detention center for 5 years, and that is not the proper time for him to prepare documents during the detention period in order to respond to all those 1,000 documents presented before him. Also, another aspect is Mr. Kyosampon's health. Although he is younger than Nuon Chea, it does not mean he is a full-strength youth. He has also experienced some health issues, and despite all that, he tried his best to follow the proceedings. For that reason, the request for 1 week additional time makes sense, and it is not in order to drag the time of the trial chamber, but it is for the benefit of the defense of my client. Thank you, Mr. President. President, thank you. International Council, Vakang, you may proceed.
Thank you, Mr. President. My apologies for these communication difficulties, but just to make sure that things are clear, we are asking for a genuine time break to make it possible for Mr. Kyosampon to work with his lawyers on the documents and themes which the civil parties, prosecutors and judges wish to take up. We request that this amount of time be calculated as of the point when we receive all of those elements. As my learned colleague said, this is a very particular kind of trial. We're judging evidence that goes back 40 years. The accused are all about 80 years old or more. They are elderly. Mr. Q-Sampan and Mr. Nuncher in the special cell attend the daily hearings, and it's quite taxing. We do not have the staffing strength that the prosecution does, and you can see that the prosecutors take turns in these hearings to question the witnesses, while we are always the same individuals. So hearing time is not a time when we can devote our resources to doing anything else. Our teams are smaller, and in addition to that, the death of Mr. Yang Sari has reinforced the imbalance, because it's made it possible for the prosecution to reallocate their team members who were dealing with that to other tasks connected with the two remaining accused. And in our view of things, this would warrant a 3-week break after the end of evidentiary proceedings to allow us to prepare. And the deadline would be as of the communication of those lists, after which we would request the 3 weeks. And we would also like to have access to our client during the weekend. The prison is closed to us at the weekend, as things stand at the moment. And we think that the concentration potential of a gentleman of 80 is not the same of somebody of 40. And what I'm therefore telling you is that we cannot effectively work for a whole day with our client on documents and so forth. That's the first reaction I have to the response of the prosecution. We believe that the time allocated is a kind of maximum, Mr. President. The time for questions seems to be suitable. I will have to talk about this with my client, of course, because that will be burdensome for him. As to the closure of hearings and the preparation of the closing briefs, we would request a final list of all documents receiving the E3 code. As I see it, tell me if I'm wrong, of all documents, Mr. President, that your chamber will use for its reasoning and to substantiate its verdict. Mr. President, so far we are talking about 4,000 documents, and you are going to take a decision on the basis also of written documents instead of submissions by actual witnesses. I won't go into this. We've already submitted matters in writing on the subject, but we have 5,500 documents roughly, and we would like to have a list. When we submitted various requests asking for clarifications about E3 documents, we were referred to the daily notes of the greffiers. But to give you a very simple example, so far the last daily hearing report from the greffiers that we officially received dates back to February. So we seem to be getting these months afterwards, and in order to be able to begin proper work on the closing briefs, we do demand that we be given a list of the documents considered by the Chamber as substantiating its eventual decision. We need time to review translation problems. We've had some quite considerable problems in this area. Frequently, we see Khmer transcripts that are at variance with French or English ones. Let me give you a very simple and recent example. In preparation for this hearing, I made some submissions in E288. Yesterday I was talking with my Cambodian colleague on the Khmer version that was submitted, and lo and behold, where I was talking about the death of Mr. Ieng Sari made it possible for the prosecution to increase the staff strength for its work. It says in Khmer the death of Nun Chair means that the defense has more resources to do its work. That's one example of serious translation problems, of which there are many others. And we would like, before we calculate the deadlines for our closing briefs, that there should be an additional fortnight to revise the transcripts. And this is a huge task because I think we have reached 87 witnesses and there's a huge amount of work to be done there. A comparative task of alignment. We have a very small team and 2 weeks seems to us to be a minimum to do that job. Once all that has been covered, we believe that we need 2 or 3 months to draft closing briefs of 300 pages. As I said, even 300 pages, as I see it, is an extremely restrictive figure. On the other side of the room, there are noises coming that we are being supported by this, by them in terms of the footnote layout. But the 100 pages that are being allowed to us by the Chamber, I really don't know what you're meant to do with 100 pages when you've got 87 witnesses, hundreds of days of hearings, and goodness knows how many thousand documents. Nobody can achieve the impossible. And as regards the closing arguments, we would ask for the time given to us to prepare them be calculated from the moment when we receive the adverse pleadings in French or Khmer, depending on whichever language client can understand, because French is a possibility, Khmer is a possibility, but the prosecution writes in English. So we would like the delay, the deadline, to be calculated as of the moment when we have a translation in a language that our client can understand of the adverse arguments. And then an additional final week for the preparation of the closing argument. Thank you.
The President, Council Kope, you may proceed.
Thank you, Mr. President. The Nuencia defense team would also like to go on record that we concur with the position of the Kyo Sampan team and the prosecution in respect of the amount of pages of the closing brief and the amount of time allotted for our closing arguments. It has been said all over. It has been said before, so I won't do it again. But 100 pages covering 6,000 documents, many thousands of pages of witness testimony, that seems to be impossible. And, an average domestic drug case would already take 100 pages just to make an argument. I know the Chamber has decided about this 100 pages limit, but we have just heard, if I'm informed correctly, that you have announced the decision admitting another 1,500 written statements, including about, I presume, 106 written statements in respect of the non-null or the policy of killing non-null soldiers. You know from our courtesy copy of our request yesterday that we challenge these accusations. And in order to be able to properly make our defense arguments, Mr. President, I think we really need more than those 100 pages. And I'm also not quite sure the rationale behind the limiting to those 100 pages or limiting the amount of time needed for the closing arguments. This is an incredibly comprehensive and complex case, maybe the most complex and comprehensive case since the Nuremberg and Tokyo trials. I know there is something to be said to limit parties in their submissions, but 100 pages seems to be the other extreme. Again, to be on the record, we really need to be given more opportunity to properly state our case and not to feel restricted in our arguments. We have absolutely no reason to come up with superfluous arguments or to use our very limited time with arguments that don't make any that are not relevant. So, to sum up, Mr. President, we do support the positions taken by the Secures and Fund defense team and the prosecutor that we really do need more time to not only prepare but also to make our written arguments and our closing submissions.
The President. Thank you, Judge Jean-Marc Lavange. You may proceed.
Oui, merci, Monsieur.
Yes, thank you, Mr. President. I would like us to revisit the proposal made by the co-prosecutors, and the proposal is that the closing briefs be separated from the footnotes and filed at different times. May I know whether the co-prosecutors have an idea as to the number of pages of footnotes? I ask this question because footnotes are generally written in tiny print and require a lot of time for translation. Let me also point out that when we go into the details of footnotes regarding not only giving references in the source language, you also have to make sure that those references are coherent across the three official languages or the three working languages, and you may face surprises. So this problem should be borne in mind because the closing briefs cannot be filed only in one language. So my first question is whether you have an idea as to the number of pages required for those footnotes.
Thank you, Judge Laverne. Firstly, I'm not sure whether it's a translation problem, but the prosecution are certainly not saying that the footnotes or the endnotes and the closing argument proper be filed at a different time. It would be filed at exactly the same time, simply that the footnotes would appear as endnotes. Your Honour, as far as the the possibility of putting the sources of the evidence, the references, in 3 different languages relating to the English, French and Khmer translation. Certainly in case file 1, the prosecution was absolutely unable to do that in the time. We would submit it's virtually impossible to do that in a very, very short period of time. It would take months and months, and that's why in the case file 1, certainly the parties only put it in 1 language, not the 3. I think we would need sort of staffing size far bigger. Everyone would need a staffing size far bigger than anyone's got access to. I would submit that in the time frame given, it's virtually impossible to be able to put the references in 3 languages. That's how we've. I can't see any other way unless the staffing sizes increase. Your Honours, just in relation to the briefs, I mean, the prosecution has 2 responsibilities. One is to make sure that whatever it puts forward is found if it's a finding of fact beyond reasonable doubt. That's one issue that guides us in our submissions today. And the other issue that, the trial is fair and everyone has a reasonable opportunity to say what they need to say at the end of this case. The prosecution, we certainly wouldn't object to an extra 50 pages for the, in addition to the endnote situation, we wouldn't object to an extra 50 pages to each of the defence teams and raising the prosecutions to 250. We wouldn't object to that. But because people should have the ability to be heard on their cases. But, one way around it, and it doesn't perhaps solve the problem completely, but certainly it significantly addresses it, is the turning the footnotes into endnotes. Your Honours, and so we would support the defence to that extent. Your Honours, just one point I would like to raise. We're almost at the end of the trial, and we've heard from Q Sampan defence, complaining again about a number of issues, and this time they're complaining about they don't have enough resources. Now, I haven't heard in this case at any time the Q Sampan saying that they've got inadequate time and facilities to prepare their case, and I haven't really heard them ever say that the prosecution size is so much bigger, the resources, than the defence. And just to set the record straight, Your Honours, so that the public understand, the statement that the prosecution changed prosecutors to question the witnesses, that's clear, that's obvious, because obviously the amount of detail required. But so does Q Sampan. There's 3 other international. Sorry, I'm not sure if we're getting translation, but there's 3 other international counsel. Mr. Jacques Vergès has been on this case since the beginning. Perhaps he's in Paris writing the closing brief now. And we have his other co-counsel, who obviously prepares while Mr. Verken is in court. So this idea that somehow or another the prosecution are doing things differently to what the Q Sampan are doing, it's just not correct. And the other issue we would like to put on record is that the prosecution are not just prosecuting one accused, we're prosecuting 2 accused, 2 defence teams. And secondly, we're also involved in the investigation or the supervising of the investigation of 2 other cases, case file 3 and 4. We don't, and without going into the numbers this morning, because we've done the calculations, the prosecution resources are no bigger combined than the defence, bearing in mind their other responsibilities on other cases. And other lawyers in our prosecution office are working on those other cases, as is our responsibility. So I would just like that to be clear on the record, that there is not an inequality of arms. And secondly, it's interesting how this is raised right at the last point of the case. One would have thought it would have been raised earlier if it was a serious issue. Thank you.
The President. Thank you. The time is appropriate for adjournment. The Chamber will adjourn now and resume at 11:05. The Court is adjourned.
សូមអញ្ជើញក្រោកឈរ